the distribution of assets, but an estate plan I would characterize as being a more comprehensive set of documents, and in some respects communication over all of your matters relating to who you want to make decisions for you in the event of your incapacity, as well as who benefits when you pass away. So that's estate planning I would characterize as more of a comprehensive term for how you plan for what is left behind when you die.
Okay, thank you. And at what milestone in life, such as getting married, having a child, reaching a certain age, or when should a family consider having an estate plan drafted?
Well, any of the above, certainly. I think milestones are the biggest time to evaluate looking at your estate planning. As Corey mentioned, I often say that estate planning is your set of instructions for how you want assets to be passed to beneficiaries after you pass away. So as new assets come into your life, or as new beneficiaries come into your life, I think that's a great time to evaluate looking at getting your estate planning done or updated. So getting married, introducing a new beneficiary, having children, introducing new beneficiaries, identifying new important charities, moving states and buying new residences, significant changes in finances. Those are all the big milestones in life where I think it makes sense to look at an existing plan or to do one in the first place.
Very good. Now, regarding powers of attorney, what are the most common types and what purposes do they serve in an estate plan, and who needs to have them in place?
Also a great question. And the most common power of attorney that we deal with is a general durable power of attorney. And that's a document where you appoint someone to act on your behalf for financial matters. And it's a very powerful document, but important to have in place so that individuals can coordinate their finances, even in the event of things like incapacitation or inability to act. So we commonly prepare powers of attorney, for instance, for married couples that would appoint the spouse to act on the other couple's behalf. It's effective immediately, but there's a few scenarios I run past a lot of our clients where it can come in especially useful to have a power of attorney. I'll start with some of the more morbid ones, unfortunately. When we sometimes have clients who have cognitive decline, one of the spouses starts to have dementia or is unable to conduct financial affairs. Having a power of attorney allows the other spouse to sign, the spouse who has capacity, to sign on the incapacitated spouse's behalf. I've also sadly seen, especially with the onset of COVID, more and more clients who are incapacitated for a period of time due to medical treatment. A power of attorney, again, lets individuals continue to conduct finances. So wherever the incapacitated spouse's signature is needed, we can have the spouse with capacity utilize the power of attorney to act on behalf of both. And my happier example I always like to give is, especially in Minnesota where there's cabin country, sometimes we've had clients who are closing on a piece of real estate up in, say, northern Minnesota, and one of the spouses can't get out of work in time. The other spouse could go up and use this document to sign for both. So at least we can end on a less morbid one. But again, whatever the reason, it's a really useful document. If a client has someone that they trust to act on their behalf for financial matters, it allows someone to name an individual who can step in during a lot of those emergency or, I guess, occasionally happy cabin situations.
Great, thank you. Moving on, what is a transfer on death deed and what purpose does it serve?
This is a type of deed where you can convey a piece of real estate to another individual. And we don't do them very frequently, but the main objective is to do what it says it does. Provide that when you pass away, real estate passes to an individual that you may name. Oftentimes, in whether Minnesota or Florida, in my case, and I think Corey would agree in Minnesota, Wisconsin, or Arizona in his, they are, while sometimes useful, often more trouble than they are worth. But that depends on the client. There are situations where they make sense as well. But long story short, they're documents where you can convey your real estate to someone else and provide that upon your passing, it automatically goes to that individual.
Okay. Very good. Moving on. My son or daughter is married and has minor children. They don't have an estate plan in place. What's the process that would unfold if they were to suddenly pass away?
Well, that would depend on a few factors. And again, a good lawyer answer, right? It depends on a few factors. If one individual is passing away, then the surviving spouse is working to manage the estate of the first spouse who's passed. And if both spouses have passed away, then we have a bit more complicated structure in place. If the first spouse, one spouse is passing away, then we look to see if assets are owned jointly, and then jointly owned assets would pass to the spouse. If assets have named beneficiaries on them, and that's the spouse would work to receive and collect those. And then the surviving spouse would be named the sole guardian of the children. Now, if both spouses have passed away and there are minor children, that's when things are going to be quite a bit messier if there's no estate plan in place. There would have to be a guardianship proceeding to determine who is to raise and take care of those minor children. There might have to be a custodian put in place to manage the wealth for those children's benefits. So your assets would go. And there would not be clear direction as to who's acting in those two roles and for how long and to what ends your wealth is to be managed for those children.
Okay. Another question, at what point should a family consider a trust instead of a will?
Another it depends question where there's a variety of factors. Both a will-based plan or a trust-based plan, we'll talk more about what a revocable trust is later in the presentation. Either of those documents are ways that you can provide for your assets to be transferred to your beneficiaries as you wish. But there's different processes as to how which would work. So brief overview of some estate planning. If you pass away with a will, assets are deemed to be owned by your estate. So an estate is just a term for assets owned by a deceased individual. And your will is your set of instructions as to how your estate is to be managed and go, meaning go to which beneficiaries. And there's a court process called probate where you would hire an attorney, the personal representative rather would hire an attorney or maybe do it on their own if they wanted to, but they would go into court and take the will, and the judge would oversee the process according to the will of actually transferring assets to beneficiaries. Now, a trust is a separate legal entity from you. And again, we'll dive into this more later, but if you have a trust in place, you're transferring assets to the trust during your lifetime so that they're no longer owned by your estate, meaning that when you pass away, there's no need for probate administration, for court involvement, if things are titled correctly. So one of the biggest factors is kind of what are people's propensity for probate and what's people's desire to avoid probate. And that depends on where clients are at. We have that conversation, talk about based on your assets, where the assets are located, the size of the assets, the complexities of them, based on the beneficiaries involved, who's receiving assets, how are they receiving it? Are we okay with the court overview process of probate, or does it make more sense to utilize a trust-based structure and have this be an independent administration not involving your estate as much? So a few of the factors that we look at. Do you have assets in multiple states? That's a red flag for me that oftentimes when clients say, yeah, we've got a condo down in Naples, but we've got our house up here in the Twin Cities. I say, well, we'd have multiple probates, a probate in Florida and Minnesota. Do you want to deal with two court administrations? And clients might say, yes, that doesn't phase us, or no, that does phase us. Just as a common example of that as well.
Very good. Well, let's delve some more into these revocable living trusts. That's our next section. What is a revocable living trust, and why is that such a common planning tool?
Yeah, sorry, I jumped the gun a little bit there, Joseph, but revocable living trust is an estate planning vehicle. It's a separate legal entity from you. So when you establish a trust, you are creating a new legal entity which can hold your assets. Now, you still own and control your assets, but instead you control them through your trust. It's not a corporation, but sort of think how a corporation is a separate entity from its shareholders or from a board of directors. In that same way, a trust is a separate entity from you. But you own and control your trust. You can transfer assets in and out of it. If you were to look at, for instance, your real estate that's been transferred to a trust, it would list you as the owner as trustee of your trust. So it's just a different hat you're wearing. Again, remember that distinction on you owning things individually and eventually your estate, or owning things through this trust. So it's a common vehicle because it's a means to avoid probate, as we discussed a little bit in that last section. It can allow for more efficient management of assets. I mean, it's generally faster and clearer to have a trust administration where your assets are being managed by a trustee, your financial advisors are involved, likely attorneys involved, as opposed to the longer process of probate. So for those reasons, it tends to be a fairly common vehicle.
And building on that, what are some of the biggest advantages of an RLT, irrevocable living trust, as compared to just a basic will?
Yeah, I would say it's one, avoiding that court overview process. The court administration of your assets is a big advantage. And the other is a bit more of a streamlined administration of your assets, that upon your passing, your trust still exists and it clearly is listed who is the trustee to act on your behalf. There's no need to have a personal representative appointed, as is the case in a court administration. So the trustee could call us and financial advisors and accountants and begin working on the process of administering your affairs much more quickly than they would if we had to wait for a judge to sign off to make sure that your will was executed correctly and clearly list the right people in that as well.
Great. Okay, and we'll talk more about tax planning and how they fit into that too. One concern we hear about revocable living trust is the hassle and complexity of setting it up. What would it look like to use your firm to establish a RLT, and how long would it reasonably take?
Yeah, that's a concern that I've heard as well. For when we work with clients and do a trust-based plan, we often explain that there's two phases to planning with a revocable trust. The first phase would be actually preparing the agreement itself. Corey and I do that, and I'd say typically 4 to 6 weeks, but that again is very client dependent. That's the time frame whereby we meet each other, get to know our goals, values, make sure that we understand what you want to do in your estate plan. We then prepare your documents, review them over with you, make sure that you're comfortable with it, make any edits and answer any questions that you have, and then meet to actually sign and execute the documents. That's phase 1. Phase 2 is transferring assets into the trust. So we help with preparing deeds to title any real estate into a trust. We make that as kind of part of that 4 to 6 week process. But afterwards, that's where we work with our clients to retitle assets into a trust. And that's where we coordinate with clients, often their financial advisors, to make sure that investment accounts go into a trust as needed, retirement accounts reference a trust if necessary, life insurance policies pay to a trust. We basically go asset by asset to make sure that things go accordingly. So as you can imagine, the more complex your affairs are, the more assets you have, the more complicated your assets are, the longer that would take. The few, maybe more streamlined your assets are, the simpler it is. But honestly, and Corey might agree with me on this, the biggest indication of whether it's a hassle or not usually is the financial advisors. When we work with great financial advisors, such as these, it's a very simple process. It's often wrapped up by the time that you meet with your FA, or whether that's after kind of in coordination with us, you meet maybe the week or two after you get your documents signed, or by the time of your next annual or semi-annual, how frequently you meet. At that point in time, your financial advisor, who knows what all your assets are too, can help with preparing any forms to transfer an asset into your trust, make sure beneficiary designations are updated and the like. So it's honestly, my clients who have a good financial advisor often say it's a very simple process.
Many hands make light work. Yeah.
Good. The next question is more about charity. If I want to leave a substantial portion of my estate to charity, how does that impact my trust?
Yet another it depends answer, if I can give that. Depends on factors. One thing I like to do with my charitably inclined clients is to look at their assets and see which assets we want to have earmarked for charity. Sometimes I have clients who are charitably inclined, and we look at their other goals and realize it might make sense to not have any charitable donations after passing, but to instead accomplish charitable goals during our lifetime and then provide for other beneficiaries in the estate plan. Or we might look and say, is there a specific asset that, whether for tax reasons or for a variety of other reasons, I suppose, tax is usually the main one, will be designated to go to charity. So the trust itself might not ever own this asset, but this asset, like maybe a retirement account, would pay to a charity or two. So maybe the trust wouldn't reference it. But lastly, it is as simple as writing a charitable beneficiary into a trust, and we can determine whether it's a set dollar amount, and is that amount indexed to inflation, or is it a set specific dollar that's going to stay constant, or do we give a percentage of our assets to charity? But that it could just be written in the trust, no differently than writing in another beneficiary.
Okay. And do both my spouse and I need a trust, or is one enough?
The theme of the presentation, it depends. There's factors involved. For Minnesota and Florida, the states I'm licensed in, I often am recommending having a separate trust for each spouse. And the thinking being that these trusts step into your shoes, just like how there's two individual people in your marriage, there's two trusts that operate and coordinate your finances. There's a few reasons for that. From a tax planning standpoint, you get a full step up in cost basis and assets owned by a trust when one spouse passes away, and a joint trust that's a half step. And it's often simpler for the surviving spouse to modify the estate plan if they have their own trust. Sometimes with joint trust, there are restrictions in place as to what changes can be made when the first spouse passes away. And so we've run into situations where say that you are giving to 3 children during your lifetime and you've given unequal amounts, and the spouse that, one spouse has passed away and the surviving spouse wants to adjust those gifts made at passing. We found situations where a joint trust sometimes encumbers what the spouse can do. So unless my spouses want to lock in the plan, a joint trust can be more cumbersome there too. The only times I can think of where I would say a joint trust makes more sense are in some states where there's a concept called community property, where it's an asset does need to be owned by a joint trust. But again, for me, those states are not Minnesota and Florida, so it's not too common that I'm in that situation.
Okay, thank you for that clarity. The next section is on irrevocable trusts. And Matt, I'll turn it over to you.
Thanks, Joseph. Topic 3, irrevocable trusts. What are the main differences between a revocable living trust and an irrevocable trust?
Yeah, and I'll take that question, Matthew. The main differences are who benefits even during lifetime. So if you, as the owner of an asset, decide you want to benefit children or grandchildren even during your lifetime, you might consider creating an irrevocable trust. And for tax planning reasons, you can create that trust to benefit them, that is children or grandchildren, even during your lifetime. But in order to maximize the tax benefit of that, you really have to relinquish control over the assets that are contributed to that irrevocable trust. So as opposed to a revocable trust in which you retain the right to your assets to use and consume those assets perhaps during your retirement, an irrevocable trust must be legally parting ways with. You must be legally parting ways with those assets in order to achieve the desired tax outcome. So with an irrevocable trust, you're typically naming children or grandchildren to benefit from those assets even during your lifetime, as opposed to a revocable trust in which you're continuing to use those assets for your own needs.
Very good. What are the most common misconceptions about irrevocable trusts?
Well, I could say 2 things. One is that there is no simple answer when it comes to sort of medical assistant spend round rules, where some folks come to us and say, I want to make sure that the government's going to pay for my medical care. And I've heard about an irrevocable trust. Right. So I want to talk about that. Well, in order for you to have estate tax benefits of not being considered to be the owner of assets, you got to part ways with those assets. And similarly, in order to sort of on a separate matter, a separate hypothetical scenario, but if you have gone through your assets in terms of medical expenses and you want your assets to not be further spent down in medical assistance costs or medical costs, you really got to part ways with your assets. So in order to do irrevocable trust planning well, you got to part ways with the control of the assets. The other is when I talk to our clients about irrevocable trusts, some of them quite rightly say, well, I'm not a Rockefeller, right? That I don't have $40-50 million and therefore I'm not a candidate. But just from a Minnesota estate tax planning perspective, we generally recommend that single clients who have assets north of 3 million and married clients who have assets north of 6 million at least consider gifting strategies, because if you pass away with assets in excess of those thresholds, at least under current law, to your point earlier, today is a good day to talk about this on election day, but at least according to current law, that those assets would be subject to Minnesota state taxes if you die as a Minnesota resident with assets in excess of those thresholds. So you don't need to be a Rockefeller to consider an irrevocable trust.
Thank you for that explanation. In your opinion, what is the most compelling situation to use an irrevocable trust? And I think you touched on that in your previous question, but feel free to fill in any gaps.
Yeah, I'm the first to admit that as much as Chris and I talk about tax planning, most of us don't let taxes drive our life decisions, right? So as much as important it is that we consider tax planning, I think that in certain scenarios, it makes sense to create an irrevocable trust where you are comfortable with parting ways with the asset. I think that's just the critical element. If you look at your financial statement, you believe that the Lord's going to provide for you with your other assets, you can part ways with assets. Why not do it? You know, ultimately, you got to feel comfortable with it. So Chris and I could bore you to tears with all the tax planning benefits for doing that, but you ultimately have to feel comfortable with it.
Very good. What are the most common asset types that would be placed in an irrevocable trust?
I would say that the two most common types of assets that are placed in an irrevocable trust are marketable securities accounts, so investment accounts that are placed into an irrevocable trust. Historically, it's been for children, but increasingly, I'm seeing a lot of our clients gift marketable securities into an irrevocable trust for grandchildren, and that is to say, sort of future either education costs or help with the down payment on a house. The other is a non-controlling interest in a family business. So the idea being that you're parting ways with some, but not all, of a portion of your family business. You could transfer the ownership of a limited interest or a non-voting interest in a company to an irrevocable trust so that it's not considered to be part of your balance sheet for state tax purposes.
Very good. And last question on irrevocable trusts. Can I have both an irrevocable trust and a revocable living trust in my estate plan?
Yes, absolutely. You know, the revocable trust is the centerpiece of the plan. It would be the legal framework for what assets you die with or assets you control at your death. So we'd recommend that you have that. And then if you decide to part ways with assets during your lifetime, you could create an irrevocable trust as well.
Our last topic is life estates, and I'm going to go ahead and pass those questions over to Joseph.
Okay, what is a life estate and what purpose do they serve?
A life estate is in some respects, a prearranged legal relationship between the holders of what's called the life estate and the remainder men or remainder persons. And it's just a way of historically holding title to real estate in a manner that is designed to ease the administration or ease the transfer of assets at death. So it is a means legally of avoiding the court involvement at death. So if you have a life estate, you're creating a structure with the county in which your real estate is automatically transferred to the person or group of people who are listed on the deed as being the recipients of that property when you die.
And how is that life estate different than the irrevocable life trust?
Yeah, well, it is much different because in some respects, a life estate is sort of a pre-packaged gifting strategy. It's a strategy in which the state is sort of telling you what the gifting strategy is. Okay. And the gifting strategy is when you give a life estate, or when you create a life estate, if you're the original owner, you are, as of the date of that life estate creation, giving a certain percentage of the value of your real estate to the remainder persons. And the difference between that and an irrevocable trust is, in an irrevocable trust, you can design the assets that go into the irrevocable trust when the beneficiaries receive it, even when the assets that are in that irrevocable trust are to be sold. So there's far more flexibility over how an asset is administered if it's in an irrevocable trust as opposed to a life estate. Because by way of example, if you've got land in a life estate and you want to sell during your lifetime, you got to get the agreement of the people that are listed as the remainder persons to sell. And then when you sell, the remainder persons get a certain percentage of the sale proceeds, even if you had done it for the purpose of avoiding probate over the land. So there, it is a little bit of a trap for the unwary when it comes to estate planning.
And when is life estate most commonly used?
Well, it had been very commonly used in Minnesota up until 2003 as a means to allow folks with farmland or residences to avoid medical assistance spend down rules. So it was historically a common way of avoiding medical assistance spend down rules, but it is most commonly done, certainly not by our firm historically because of the issues I've mentioned, but it's been done historically as a means to avoid probate. So Chris mentioned earlier the hassles associated with the court involvement, and life estate has historically been viewed as a way to avoid the court involvement, because in some respects you're already designating who the recipients of the land will be when you die.
You already touched on this, but what are some of the biggest disadvantages of using life estate?
Yeah, I just that were the biggest disadvantage, I think, to the life estate strategy is that the fact that when you create the life estate, you have already determined, or more specifically, the IRS has determined what percentage of the land your remainder persons own. The remainder persons are deemed to own a certain percentage of the land based upon your life expectancy. So if you sell it before you die, then the people that you've named as the remainder persons not only have to be involved and to sign at closing when you sell it, they also receive a certain percentage of the proceeds based upon your life expectancy. So that's where I like to use an irrevocable trust in most cases over a life estate, because we're able to control when it is that the beneficiaries that you like the people that you'd like to benefit truly benefit. And typically that decision is made independent of when the land is sold.
That completes section 4. So Matthew, I'll turn it over to you.
Right. So now we're going to try to take these various concepts and then integrate them into case studies or realistic life scenarios. And the first one is going to be Jack and Jill, who are both 70 years old, and they are residing in Minnesota. They have a net worth of $2 million. They own a hunting property in the state of Kansas. They have 2 children, 5 grandchildren. And because their projected net worth does remain under $3 million, even if they live until 90 years old, would a will structure be sufficient in their case?
It might be. It would depend on sufficient to what end, I suppose. But, they certainly could have wills in place to provide for their assets to be transferred to presumably their 2 children upon their passing, or to their 2 children, then maybe some amounts to grandchildren. But it would be more complex. There'd be two probates at least. We'd have a probate in Kansas for the hunting land, and then we'd have a probate for the assets in Minnesota. So they can rest assured that a will would be a way to provide for the assets to be transferred the right way. But if we had a revocable trust, we could put the assets of both Kansas and in Minnesota into it to then have just the trust administration. No need to go to court in Wichita or court in, Eden Prairie or Bloomington, wherever they are up here too.
Very good. So it would perhaps simplify their situation to have the revocable living trust.
I would say significantly, Matthew. Yeah, I would say significantly simplifies it.
Fantastic. Next case study, Miles and Linda. Miles is 62, Linda 58. They've recently retired after raising their two children and living in Minnesota for their entire lives. Miles and Linda purchased a condo in Florida 5 years prior, and they now intend to live in Florida 7 months of the year, and then the remaining 5 months back in Minnesota. This effectively establishes residency for them in Florida. They have a net worth of $5 million, and that is projected to remain fairly steady with their lifestyle plan. They established a revocable living trust prior to the purchase of the Florida condo, but have done nothing since. What changes should they consider making to their estate plan since purchasing their condo and then subsequently becoming Florida residents?
Yeah, great question. And I would, having done this situation many times, there's some benefit to reviewing over the trusts that were drafted in Minnesota and having now become trusts under Florida law. So for instance, anywhere the Minnesota statute was referenced to say, the trustee has authority to act under these Minnesota laws, we could update it to have it go to reference Florida laws instead. Again, nothing inherently wrong with the Minnesota references, but it allows for a smoother trust administration. But really the biggest thing that my Minnesota Floridians or Floridian Minnesotans find is that because they were worth $5 million in the situation, they had a taxable estate in Minnesota, right? Their combined net worth was over $3 million in Minnesota. So there often are provisions that they would have had as just traditional Minnesotans that would have provided for assets to be transferred to various sub trusts underneath the trust agreement for tax planning purposes. Kind of like Corey was saying with an irrevocable trust, there might have been some planning in place where the surviving spouse might have given up some control over part of the first spouse to pass away's assets in return for them being not owned by the new spouse, to not have it be a taxable issue there. But now that they're Florida residents, Florida has no state estate tax. So we would look and say, let's look at what assets are sitused in Minnesota, see if we could project what a hypothetical Minnesota state tax might be, again, just on those assets, because those assets in Minnesota would be subject to tax, but not the overall estate. And we could probably simplify their trust agreements to have a little bit easier on the eyes, I should say, easier on the eyes to have a little bit simpler tax planning provisions in place.
Excellent. So not necessarily a complete overhaul, but absolutely revisions would be worth looking at.
The legal term is tweaking. We slightly adjust or tweak. Yes, exactly.
Yeah.
There's some modifications that we would make. So really, it's probably what I've done most often is to add new provisions for Florida law and to, again, modify the tax structure to have maybe things that would have been in place for Minnesota be removed because we can have a simpler point. And I should also point out, Florida has, I'd be remiss if I didn't mention, pretty generous homestead laws. So we also include homestead provisions for our Florida clients that are not in our Minnesota documents. And without having those provisions in place, that Florida condo wouldn't have the same, creditor protections and tax benefits that it has if it was owned by just the Minnesota trust without that homestead reference.
And if I could interject one issue, this hypothetical hits a nerve for Chris and I, because we deal with a lot of migratory clients. Folks, a lot of our clients have more than one residence in one of which is in a warmer climate than Minnesota. And one of the things that is in some respect aggravating, perhaps for clients as well as the attorney, is when you have clients of ours who are spending significant amount of time in multiple states. One of the things that we might suggest or might consider is having what are called powers of attorney drafted and signed under the laws of each of the states in which they spend significant time. And so the idea is that if you're in Florida and something happens to you or your spouse, that you have a Florida state power of attorney that authorizes, say, spouse or daughter or son to make decisions on your behalf under Florida law or in Arizona or wherever you might be, so that there's fewer barriers thrown up by those third parties. And I think of the bank specifically with a financial power of attorney, so that they can't make the argument, well, this is a Minnesota power of attorney and you're talking to me in Miami. So that's just one thing that we've found to work best ideally, is that if you spend significant amount of time, that you have powers of attorney specific to that state.
It's very insightful. Our last case study, Brian and Tracy. Brian is 57, Tracy 58, are still working full time and do not plan on retiring until they reach 67 years old. They have 5 children with ages ranging from 29 years old to 17. Brian and Tracy's net worth is around $400,000. They hope to pay off their home by the time they reach 70 years old. They do not have an estate plan currently drafted. 2 children, Adam and Kelsey, have dealt with mental health issues and substance abuse and are currently estranged from the rest of the family. Brian and Tracy are worried that Adam and Kelsey wouldn't be in a position to responsibly care for any inheritance at this point, yet they absolutely want each of their children to get a share of their estate proceeds when that time comes. What estate planning options should Brian and Tracy explore given their situation and their concerns?
Chris, do you want to?
Sure.
Okay.
You know, either way.
Yeah.
So they would definitely want to explore looking at, whether they utilize a will or a trust, some means by which they designate that when the second of them passes away, their assets go to each of the children in equal shares. And there's 2 ways by which someone can receive an inheritance, either outright or in trust. So, Corey and I try to buck this trend. Lawyers are not always the most creative bunch. So we're not talking about trust agreements. We're talking about in trust. So again, this could apply to either an inheritance under a will or under a revocable trust or an irrevocable trust or any other means by which it's given. You can provide that a beneficiary receives something outright. And that means kind of intuitively what you're probably thinking it means. Once an estate or a trust is administered and distributions are made, the individual who receives that inheritance can do with it whatever that individual wishes. They can give it all away, they could spend it all at once, they could invest it wisely, or some combination thereof. Now, if we leave something to someone in trust, what we're doing is we're providing that a third party holds on to that share under terms established in the will, in the trust agreement, etc. That explains how the wealth is to be managed for that individual. So if there are concerns in the situation that these are children who we absolutely love and want to be treated equally in terms of the wealth they receive, but that we have concerns about the decisions they might make, we could appoint another person to hold on to that share for those kids and give direction to that person as to what sort of spending goals we're to have. And not spending goals is the wrong way to phrase that, but I mean, what sort of objectives we want to accomplish with the share. So for instance, if these mental health issues relate to medical assistance, we could make sure that the trustee looks at what sort of care the person's receiving from various government programs and doesn't make gifts that would cause that gifting to be lost, the government to not make those distributions anymore. We could provide that someone has to go to a rehab facility or has to demonstrate sobriety for a period of time. We could provide someone has to receive other kinds of treatments or has to reach a certain age or accomplish a certain goal before which assets would be distributed. It's a way that we can make sure that someone still gets treated to be the same as the others and that they get the same amount, but that there's somebody else who's in place to hold on to it for them and make sure that it's really managed the right way.
Excellent. Good. Corey, Chris, anything else to add on to this particular case study?
Well, I was just going to add on to Chris's good comments that, this is an issue that it comes up quite frequently. And sometimes clients say, well, I don't want to rule from the grave, right? Because in some respects, what you're doing is you're giving direction for how assets are to be used and administered for the benefit of a loved one after your death. So in some respects, you're exercising what some famous judges called the dead hand, that you're directing how the assets should be directed for the benefit of the children. But we make the argument that depending upon the situation, that it really is to their benefit to make sure that the assets are used for laudable purposes and not to sort of further aggravate the situation that they're already in. One thing that we're finding works best in situations like the hypothetical that's posed here is really, it's a two-part strategy, is that we create the trust, the legal relationship that applies once Brian and Tracy pass away. So there's the legal framework, and then you name a trustee who in many cases is not one of the siblings or not a family member. Just to make sure that to the extent that discretion has to be involved, that a sibling is not the one who is the gatekeeper of a sibling's inheritance. So just something to consider for our client families as they consider the use of these types of unique structures for certain of their beneficiaries.
Very good. Well, that concludes our final topic. And now is the time to enter your questions. Hopefully this little graphic is helpful as you navigate where to submit your questions. And then I'll go ahead and read applicable questions out loud, and we'll do our best to stump Chris and Corey. Okay. So I have a question about special needs and supplemental needs trusts. We did discuss that a little bit, especially on this last case study that we looked at for Brian and Tracy. Corey and Chris, would you guys mind taking just a minute to talk a little bit about some of those really popular terms, spendthrift trusts and special needs trusts? Would you mind discussing those a little bit more in kind of a broader context?
Sure. I'll break those down a little bit. A supplemental needs trust. Let's start with a supplemental needs trust. A supplemental needs trust is a type of trust of a type that Chris and I just briefly described a minute ago in Brian and Tracy's hypothetical situation. You could create an estate plan in which you have certain legal strings attached that you are exercising sort of the dead hand, so to speak, ruling from the grave, in which you're saying, say in Brian and Tracy's perspective from their hypothetical, 20% or whatever percent that you direct goes into a unique type of trust that supplements but doesn't replace a beneficiary's public benefits. So a supplemental needs trust is a trust that is intended to supplement but not replace means-tested public benefits, such as certain types of Medicaid, housing allowances, other types of state and federal aid. Those are typically means-tested in the sense that the people who are on these programs have to document that they don't have a sufficient amount of income or assets. And so by having a supplemental needs trust, we create a structure in which those assets allow for the beneficiary to continue to retain eligibility for those programs, but have distributions supplement them. A spendthrift trust is perhaps a broader term. A spendthrift trust is any trust in which the assets of the, say, child's trust can't be attacked by that child's creditors. So, for example, if I receive a trust from, say, parents or grandparents, and I've got individuals who are suing me or coming after my personal assets, if the assets are in a spendthrift trust, those assets under Minnesota law are not, at least at the outset, can't be used to pay off my creditors. So there's that protection that's afforded to the assets that are in the trust. So that's another benefit for those folks who are concerned about ruling from the grave, You know, if they've got beneficiaries who have financial troubled past in terms of financial mistakes, perhaps, and creditors or a history of bankruptcy, for example, the assets that are held in a trust are not subject to loss just by reason of having the assets go into a trust. And then the last trust you mentioned, special needs trust, that is a unique situation in which somebody who is seeking to become eligible for a means-tested government program has assets owned by she or he, by them individually, and they want to put the assets into a trust and become eligible for a means-tested program. So that's different from a supplemental needs trust, because a special needs trust is a trust that the person who's becoming eligible for, say, medical assistance or other means-tested programs is actually creating with their own assets, as opposed to most of the situations we deal with are supplemental needs trust, in which we're creating a trust for the benefit of another individual who is on those programs.
You're gonna have another question on a transfer on death. Does a transfer on death registration for a investment account supersede a will? How does that work? So if a will, so I think the question is if a will designates one beneficiary, but then conversely their investment account is designed to transfer to a different beneficiary upon death, then which one wins out?
Yeah, whatever the beneficiary designation reads is going to supersede whatever is in the will. So if a retirement account lists individuals as the beneficiaries, those individuals will receive that retirement account. If another account has a beneficiary designated, that would supersede the will. The will would just govern assets owned by the estate. Remember, assets owned by you that don't have any designation on them. So important part of what we do is coordinate to make, again, working with clients and their financial advisors to make sure that assets that have a designation go consistently with what the will or the trust say.
Okay, so here's a question. If we have a will dividing our assets equally between our two children and have assets worth under $1 million, do we need a revocable living trust?
It depends.
Yeah.
It depends on things like what sort of assets are we talking about? What's your proclivity to probate? Are you concerned that probate's going to be a costly process? Do you think it'll go very smoothly? It would be a matter of kind of meeting with an attorney and talking about your other objectives besides just having everything going to the survivor and to the two kids.
What kind of costs are potentially involved in setting up a revocable living trust? If a person was going to look at it, what would be a reasonable range of cost to establish that kind of a vehicle?
Yeah, I typically estimate here in the Twin Cities for costs, generally about $2,000 for a single individual, perhaps $3,000 to $4,000 total cost. Just depends upon the factors that Chris mentioned earlier, that the number of assets, the number of real estate parcels in particular. As Chris indicated, in order to do revocable trust planning well, you not only need to create the agreement, but also transfer the ownership of those assets that would cause probate. And I think it was the first hypothetical with a couple that had assets in two different states. That's a good candidate for a revocable trust plan, because we're wanting to avoid probate and the court costs associated with two different states. So, in a situation like that, it might be $3,000 for the planning during lifetime to avoid two different probates, which just, rule of thumb, if it's $3,000 or $4,000 per probate in each state, then, I know it's apples and oranges in terms of comparing costs before and after death, but if you look at it just from an easy number perspective, it does make sense from a cost benefit analysis.
I just got a question on, so in the context of revocable living trusts, if you have both a home residence, but then also multiple rental properties, does it make sense for all of these said above to be placed into the trust? How would a person navigate if you've got multiple properties at play?
That would be part of a conversation to have with the client. I think if there is a revocable trust in place and we have real estate that's not owned by it, that's in your individual name, then we have to have a probate administration for those properties. So oftentimes my clients say, well, we want to put this in the trust, but, and this is a whole nother can of worms, possibly, if someone is renting out properties, we often work with that client to explore setting up an LLC as a rental business to hold those assets instead.
Can you guys talk about some of the most tax-friendly, potentially, hopefully warm states that should be explored? And then conversely, what would be some of the worst from a tax favorable standpoint that a person might consider avoiding from that standpoint?
I'm only licensed in Minnesota and Florida, so I abstain from any commentary that's not Minnesota or Florida related.
Well, on election day, we should first make the disclaimer, we're not endorsing any political candidate here at this point in time, but Minnesota is the 46th best state when it comes, according to the Wall Street Journal this weekend. In other words, it's the 5th worst state when it comes to taxes. So just about every other state is better. Now, there's a couple states, I think New Jersey, New York have a higher marginal income tax rate, but when you combine the state income tax rate with the estate tax rate, it's a pretty tough state from a state taxation standpoint. So yes, all the warmer states are better. Arizona, where I'm licensed, has a state income tax, but no estate taxes. And other states, pretty much all of the Northeast United States, the Connecticut and New Jersey, New York, they have estate taxes. Illinois has a state tax, as does Minnesota, but most of the warm weather states have no state level estate tax.
Very good. Here's a question on moving. So we had previously had a estate plan done with mainly wills living in a different state. We moved to Minnesota 2 years ago. When's a good time to consider having an attorney look over those documents to see what might be amended or changed because we are now living in a different state?
Yeah, upon moving, I think once you're settled, it makes sense to work with an attorney in that new state and reach out to them and see what changes are made. Again, not necessarily the Minnesota example, but as we mentioned earlier with the people who lived in Minnesota and then moved to Florida, we were able to simplify some tax planning provisions. People who move from another state, kind of as Corey was mentioning, Minnesota not being as tax friendly, we might want to look in place and say, hey, we might want to look at your documents to include some tax savings protection provisions that would be allowed to do that. But again, a will would be, most states recognize other states' legal documents, so it's not, the will wouldn't still be valid in terms of transferring assets. We just might be missing some opportunities to make sure it goes more efficiently or to make sure it's more optimal for a tax standpoint.
Excellent. Okay, one last question. Is it expensive to have a third party hold and manage the trust upon the death? Could you provide some various examples of which third parties might do this, and what should be considered?
That's a great question. Great question. In the time I've been practicing law, I've seen the pendulum swing back and forth in terms of how frequently clients are designating non-family members as trustees. So my observation here over the last couple of years is we're swinging back in favor of professional trustees. There's been a dearth of good options here, at least in the Metro Twin Cities, because some of the bigger banks have gotten out of that business. And so fewer of us sort of meet their asset minimums, because typically a corporate trustee would charge a percentage of the assets in the trust. But there have been a number of newer companies here, at least locally, who will, for kind of on an hourly basis, similar to how an attorney generally charges, serve as the trustee. So it might be something like, in the scenario, the last hypothetical we had where there was 200,000 allocated to, or say 100,000 allocated to a trust for the benefit of a beneficiary. In a situation like that, a professional trustee could charge probably a few $1,000s, say 5,000, 3,000 to 5,000, depending upon the situation per year, to oversee the tax returns, investments, and distributions. So it's an option. It's certainly, in most cases, I should say, generally more expensive than naming a family member or friend, a family member or friend. So I would say, just at the risk of being overly simplistic, more expensive, but at least with the professional trustees that we work with here in the Twin Cities, in a lot of cases, they're worth it, especially if we're trying to avoid difficult family dynamics that would otherwise be the case if you're having a family member serve as a trustee.
Great, fantastic. Well, with that, we are past our time. I wanted to thank Corey and Chris for being speakers in the event today. We all benefited from your knowledge and expertise and your time. So thank you so much for joining us. Thank you to all who have joined and made time for this. If you do have any follow-up questions or you'd like to consult with Corey or Chris, of course, you can reach out through Joseph in my office, but you will be also sent an email with some follow-up information if you do want to get a hold of Corey or Chris directly, and that'll be provided for you this afternoon. So thank you all. Have a fantastic day. God bless you, and goodbye.